Section 27. Your fiduciary duty, the rule that protects your client and your license. Your fiduciary duty, the rule that protects your client and your license. Ashley had been licensed long enough to understand contracts, negotiations, inspections, and disclosures. But during one of the brokerage's weekly training sessions, Michael asked a question that caught everyone off guard. What is the single most important rule you follow every day as a real estate professional? The room became quiet. One agent answered, the purchase contract. Another said, the code of ethics. Someone else suggested, disclosure laws. Michael smiled. All excellent answers. But there is one rule that ties everything together. He walked to the front of the room and wrote on the whiteboard, AAC R428 1101, duties to client. If you understand this one rule, he said, you'll avoid many of the complaints that end up before the Arizona Department of Real Estate. Ashley looked at the rule. It seems pretty short. It is, Michael replied, but its impact reaches almost every transaction you will ever handle. He explained that R428-1010 establishes the professional duties Arizona licensees owe to their clients and the public. It covers fiduciary obligations, material disclosures, conflicts of interest, competence, compensation, communication, agency relationships, and professional conduct. More importantly, many ADRE investigations reference this rule because it applies to nearly every stage of a real estate transaction. Michael continued, let's start with the foundation. A licensee owes a fiduciary duty to the client. Ashley nodded. I've heard that phrase since real estate school, but what does it really mean? It means your client's interests come before your own, Michael replied, ahead of your commission, ahead of convenience, and sometimes ahead of your own personal opinions. He explained that fiduciary duty requires loyalty, obedience to lawful instructions, confidentiality, disclosure, accounting, and reasonable care. While every transaction presents different challenges, the guiding principle remains the same. Always act in the client's best interests while treating everyone else in the transaction honestly and fairly. David joined the discussion. Some agents think protecting their client means fighting everyone else. Michael smiled. That's not fiduciary duty. Arizona law also requires you to deal fairly with every party in the transaction. Ashley laughed. So this isn't a competition. Exactly. The buyer should feel successful. The seller should feel successful. And both should leave believing they were treated honestly. Michael then turned to another part of the rule. He explained that Arizona licensees must disclose known material facts that could affect a party's decision or the value of the transaction. Material facts are not limited to physical defects. They may include information affecting a party's ability to perform, significant liens or encumbrances, or other facts that a reasonable buyer or seller would consider important when deciding whether to proceed. Ashley asked, so if I know something important, I can't simply stay quiet? Correct, Michael answered. If the information could materially affect the transaction, your duty is to disclose it appropriately. He reminded the class that licensees are not expected to be engineers, attorneys, accountants, or contractors. However, they are expected to recognize issues, communicate honestly, and recommend qualified professionals whenever specialized advice is needed. David nodded. Know where your expertise ends, and know when to bring in someone else. Michael smiled. That's what protects both your client and your license. The conversation shifted toward professional competence. Ashley admitted, I've had clients ask me questions about tax consequences and estate planning. What should I do? Michael answered without hesitation, don't guess. He explained that R428-1101 expects licensees to perform competently within the scope of their real estate license. When questions move into legal, tax, accounting, engineering, or other specialized fields, the safest response is to recommend that the client seek advice from the appropriate licensed professional. David added, one sentence has saved countless agents. Ashley smiled. Which sentence? That's a great question, and I'd like you to get advice from the professional who's qualified to answer it. The room laughed. Michael then discussed conflicts of interest. He explained that whenever a licensee has a personal interest, financial interest, family relationship, ownership interest, or any circumstance that could influence the transaction, those interests should be disclosed as required before the parties enter into a binding agreement. Transparency builds trust and helps avoid future disputes. Ashley looked thoughtful. So almost every complaint comes back to communication. Michael smiled. You're starting to see the pattern. Most license suspensions don't happen because an agent didn't know the rule. They happen because someone failed to communicate, failed to disclose, or assumed the client wouldn't care. David closed his notebook. The safest agents I know all follow one philosophy. Ashley looked at him. What is it? When something could affect your client's decision, tell them. When you're unsure, ask your broker. And when it's outside your expertise, bring in the right professional. Michael smiled. That's exactly what fiduciary duty looks like. And it's one of the best ways to protect both your clients and your real estate license. Real-world Arizona example. An Arizona listing agent learned during the transaction that an older roof had leaked during heavy monsoon storms several years earlier. The seller believed the issue had been repaired and did not think it was important. Rather than deciding whether the information mattered, the agent discussed the issue with the designated broker and ensured the seller properly disclosed the prior condition. The buyer later obtained a roof inspection, negotiated repairs, and the transaction closed successfully. By communicating openly instead of making assumptions, the agent protected all parties and avoided a potential failure to disclose complaint. Broker tip: never decide what information is important enough for your client to know. If a fact could reasonably influence a buyer's or seller's decision, discuss it with your designated broker and determine the appropriate disclosure. When in doubt, transparency almost always creates less risk than silence. Online discussion question 1. Why is fiduciary duty considered one of the most important responsibilities of an Arizona real estate licensee? Model answer: fiduciary duty requires licensees to place the client's interests above their own while acting with honesty, loyalty, reasonable care, and full disclosure. It forms the foundation of nearly every professional responsibility in a real estate transaction. Question 2. When should a real estate licensee recommend that a client seek advice from another professional? Model answer: whenever questions involve legal, tax, accounting, engineering, inspections, or other matters beyond the scope of the real estate license, the client should be referred to a qualified professional. Question 3. Why do many ADRE complaints involve communication rather than intentional misconduct? Model answer: many complaints arise because information was not disclosed, misunderstandings were allowed to develop, or assumptions were made instead of communicating clearly with the client and documenting important conversations.